Hello, everyone. Hope you're well. I am Margherita Birri, research editor from the Legal 500. It is a pleasure for us to have this webinar today about employment law in Sri Lanka. The Legal 500 and Tirutselvam Associates are bringing together expert speakers to discuss the evolving employment landscape in Sri Lanka in 2022. Discussion points will take into consideration the labor implication following the economic crisis in Sri Lanka. Our amazing speakers will provide some practical ways to approach these issues. So now let me introduce the speakers. Our moderator, Ramani Mutetuwegama, managing partner. She's an expert on Sri Lankan labor law and practice. Her advice is much sought after by employers and employees alike, and she has an excellent rapport with Sri Lankan trade unions. However, what makes her advice stand apart from her compatriots is Ramani's extensive understanding of Sri Lanka's socio-political norms and practices, and her capacity to provide quick and comprehensive advice to clients on the backdrop to their decisions. She has served on many technical committees on labor law reform, and her commentaries on proposed legislative changes are much valued. She's also a key advocate of gender parity at the workplace and passionate about the need to eliminate child labor globally. Her combined expertise on tax, immigration, and cybersecurity ensures the best possible advice for clients. This year, with the enactment of the Personal Data Protection Act, she supervised all data protection related queries of the firm. We have Ayendra Wickremestakera, Senior Counsel. Ayendra has more than 15 years of litigation experience in the private bar and has appeared in civil, public, and labor law related cases in the Labor Tribunal, District Court, High Court, Court of Appeal, and Supreme Court. His academic interests, together with the practical expertise of working with clients on dispute resolution, led to his appointment to the Commercial Law Reforms Subcommittee of the Technical Unit of the Ministry of Justice for the year 2020-2021, a prestigious appointment which saw Ayendra also heading the Labor Law Reform Group with this subcommittee. Ayendra has also taken a keen interest in the field of legal education and has been a key member of the Future of Legal Education Committee of the Bar Association of Sri Lanka, which went on to propose some key changes to entrance criteria to the Sri Lanka Law College. Ayendra is currently the convener of the said committee. He's presently the Deputy Chairman of the Committee for Legal Education of the Bar Association of Sri Lanka. Ayendra also served as the convener of the Bar Association Law Journal, the flagship publication of the BASL from 2018 to 2020. As a practitioner, his services are widely sought because Ayendra is that rare legal practitioner who identifies the best solution to a client's problem rather than the more obvious route of litigation. Then we have Dwaraka Ganeshan, Associate. Dwaraka's diverse practice areas with experience in the areas of intellectual property law and information technology laws enables her to provide holistic advice to clients. This year, with the enactment of the Personal Data Protection Act, Dwaraka assisted managing partner Ramani Mutetuwegama to advise on all data protection queries directed to the firm and enhance the practice. Due to Dwaraka's specializations in technology-related laws and practices, her advice is widely sought by employers and employees in this sector. She also relies on her work with the IP division to enhance the advice on data protection and privacy requirements for employers and manage the ever-growing demand for NDAs and confidentiality clauses in employment. She also works closely with the Onedata guidance team on updating MNSCs on the data protection laws in Sri Lanka. Finally, we have Eshika Rupasinghe, associate. Eshika's knowledge and expertise in the corporate affairs division of the firm has always been extremely helpful to manage many assignments in the labor division. For example, she has been involved in advising on various labor law matters, including global retrenchment programs, and handles the review and drafting of documents relating to local and global employment share option schemes. She has been instrumental in providing creative solutions to clients in managing same. Her broad corporate background helps her in providing holistic advice to clients. Her people skills assist to ensure the goal is achieved, especially when it involves hands-on communication with regulators. This has helped, as usual, to oversee assignments which involve liaising and maintaining close relationships with regulators, including the Department of Labor. Eshika is also an expert in foreign exchange laws, and this has been extremely useful in mitigating the risks and difficulties posed by the recent exchange control regulation in Sri Lanka due to the economic crisis. She regularly liaises with the Central Bank of Sri Lanka to make special applications on behalf of clients and has been extremely successful through the persuasive ability to obtain favorable rulings. Eshika also authored articles on behalf of the firm for Lexology, Getting the Deal Through, on ownership and acquisition of banks in Sri Lanka and the banking regulatory framework in Sri Lanka, and assisted with the LexisNexis PSL publication on Sri Lanka FDI Control 2021. Now, just a quick admin before I hand it over to Ramani and the speakers. The webinar will be recorded should you wish to see it again. And moreover, we would like the discussion to be as interactive as possible. So please access our Q&A question function on Zoom. So I'll now hand it over to Ramani. Thank you very much and enjoy.
Thank you, Margarita, for that introduction. At Tiruchalum Associates, we have a commercial law practice that also deals with labor issues on a regular basis. And the sad reality has been in the last few months, our labor practice has grown, and it's grown only due to the pressures of the financial crisis in Sri Lanka. For those of you who don't know, let me see. No, I guess most of you know that Sri Lanka's economy is in kind of crash mode at the moment, hopefully halted by a recent announcement of a staff level agreement with the IMF. But we're still on very shaky grounds. Our foreign exchange reserves are very low. We don't have enough money to pay for basics such as fuel, and also for other sad things like medicines, because we are not a very big manufacturing country. And so we need to import many of our basics. So in terms of the labor law itself, we have so many issues that have come up as a result of this crisis that we are actually struggling to cope with the variety of questions we come. The key set of questions are around restructuring. So many firms were dealing with the problem of reduced mobility due to a fuel crisis, reduced disruption to work due to power disruptions, and they are trying to figure out how to restructure their workforce so that they can maintain a certain output but reduce their overheads. So that's one set of questions that keep coming. Another set of questions that keep coming, and this is mainly from employees, is we've had so many different regulations on what we can do with foreign exchange we've already earned. We have expatriate Sri Lankans and Sri Lankans who live in Sri Lanka but earn in foreign exchange, who have many questions about how to manage their money and their earnings right now. Adding to all the confusion has been that a few months ago, Sri Lanka also passed our Personal Data Protection Act, which now restricts how personal data is transferred outside of Sri Lanka, but also requires certain very strict levels of protection for personal data. That seems to be adding pressure to employers right now. So we thought we'd group our discussion around these three elements. Of course, we are open to questions. We can talk about general labor law. We can talk about any other issues that may interest you. And at the end, we'll talk a little bit about maybe what we see in the future. But let's start from the beginning, which is the whole issue of restructuring, managing employment in the context of Sri Lanka's law. So Sri Lanka has a law that prohibits general hire and fire. We have to have a ground for terminating somebody, or otherwise we need someone's consent to be terminated. So that's a law we call the TEVA. And so that restricts an employer's capacity to manage things. So then they try to get around it through basics such as contractual arrangements. And then they come across the reality of Sri Lankan labor law, which is very similar to British common law. So it doesn't matter whether you have a contract or not. If you've employed someone, you can't rely on contractual grounds for terminating somebody. You have to be able to establish the reason for doing it, and you have to be able to compensate someone properly for a termination. So we have this terrible kind of tension between security of tenure for employees versus investors who have no clue when they came into Sri Lanka originally that they'd be faced with this type of pressure of no power, no fuel, disruption at work at such a level that they would need to quickly close a place, call a halt to operations, and then what to do about the workforce. And then we've seen people moving in different directions, and they've been using various procedures. We've seen them around the world. One issue that we've seen is the increasing dependency on manpower agencies to manage employment-related issues, especially in the manufacturing sector. Now, Ayendra, our senior counsel, has been involved in a series of ongoing litigation on manpower agencies and what do they mean. And Ayendra, I'm hoping you can explain to us the concerns that arise from this issue and perhaps a way forward from it.
Yes, thanks, Ramani. So basically, in the context of manpower agencies, or if I may use the term labor outsourcing companies, a problem arises with regard to identifying who the employer is. Okay, so for instance, if I may just take a simple example, what happens here is that we have a person who is an employee who has an employment contract with a particular organization, namely a manpower agency. I'll call it A for this example. And as per that employment contract, this particular employee is seconded to a third party, a company, which I will call B. Okay. Now, as per the employment contract between the manpower agency A and the employee, the contract identifies the employee as the employee of the manpower agency, as A's employee. Okay, so there is no ambiguity there. In addition to this, there is also a contract between A and B, the manpower agency and the company. Okay, and as per that agreement, also the employee is identified as the employee of the manpower agency, or A. Now, as per the agreements, it's quite clear. So what's the fuss, right? The problem is this. If you look at the actual facts and circumstances, they paint a rather different picture. Now, as you may be knowing, in labor law, identifying an employee and distinguishing an employee from an independent contractor is a key factor in ascertaining the applicability of the labor laws of the country. Okay. Now, and several tests very often are applied, like the control test, the integration test, and so on, to decide whether a particular employee is in fact an employee or an independent contractor. Now, when we go into all these tests and when we apply these tests in the context of, say, this particular employee in my example, even though the agreement between A and B and the employment contract between the employee and A clearly sets out that the employee is the employee of the manpower agency or A, the facts seem to indicate that the actual employer is B. Now, why is that? Very often, as per the manpower agreement between, or the agency agreement between A and B, the wages are paid by B, the company, right? And the money is disposed of through the manpower agency. Okay, but the wage is paid by the company, by B. Okay, in addition to that, superannuation benefits like say EPF, ETF, and gratuity are also paid by the company B through the manpower agency A to the employee. Okay, so although the employee is getting physically paid by the manpower agency, the money is coming from the employer or the company. Okay, in addition to this, in this arrangement, the employee almost exclusively works with the company B, not with the manpower agency, with the company. So he goes to work 9 to 5. He follows the instructions and takes orders from the company, from B. Okay, and he's obligated to B. And very often in these examples, the termination also takes place from the perspective of B. B terminates the employee and says, I don't want you anymore, right? Now, in that situation, or say, for example, in that situation, if these services are terminated by, or the employee is say, sacked by B, what does the employee do? If he files action against the manpower agency, against A, that person goes, look here, buddy, I didn't terminate you. B terminated you. You sue him, right? If he goes against B, that person turns around and says, look here, I'm sorry, look at your contract. You're A's employee, not mine. So you sue him. So now what recourse does the employee have in this situation? And therein lies the problem. So as Ramani mentioned, I'm handling some cases at the moment where the courts are going into this matter. And so far, there's a dearth of case law in this regard. And we are yet to see how the courts will hold. But if you look at foreign jurisprudence, say India, for example, there have been cases where the courts have held that courts have gone past the agreements. And in fact, the courts have gone to hold quite strongly that agency agreements between manpower agencies and companies are actually sham contracts to circumvent the labor laws of the country, and have gone beyond the contract and actually gone into the actual arrangement between the parties to ascertain who the employee actually works for, and have given relief to the employee. Okay, so we are yet to see how our courts will hold. There are 1 or 2 cases that don't deal with this issue directly, but they shed some light into the matter. But I think it's interesting to see which way Sri Lanka will go. But I think the only way that we can have some clarity in this regard is if we actually pass a law. Okay, if Parliament goes into it and if Parliament decides to pass some clear legislation dealing with the obligations of manpower agencies and regulating this industry, I think clarity can be found there.
And just to interrupt, the proposal for law reform was that manpower agencies are recognized as the employer. And then there was a lot of outcry from the unions, and that proposal was withdrawn. What are you proposing?
So I believe there has to be some kind of regulation, Ramani. It's difficult to identify who the employer is by legislation. I think there will be a requirement to have regulation identifying the obligations and responsibilities of both parties, both the manpower agency and the company, right, to ensure that the employee is looked after in the case of some problem. Because I don't think it's a clear-cut matter where the law can directly say, okay, in this situation, the employee is the manpower, the employer is the manpower agency. That might cause complications also. So I think there should be clear regulations highlighting the obligations imposed on both parties, the manpower agency and the company, and highlighting the rights of the employees as well.
I mean, one of the issues that came up was that unlike other types of services, for instance, employment agents and things. There was no regulatory body also for manpower agencies. So
Exactly.
you think they have to be covered by the Labor Commissioner?
Yes.
Or okay.
I think so far the Labor Commissioner doesn't recognize manpower agencies distinctly as manpower agencies. They are looked at as normal companies, right? And in fact, for the most part, they are normal companies under the Companies Act. So I think there will have to be some kind of distinct recognition of manpower agencies, and maybe a registration process where they're registered under the label of the country. Maybe that will provide some clarity, I suppose.
Yeah, because we are seeing in the labor practice a lot of questions around secondments and manpower agency type arrangements. So we can't really say that that should be outlawed also, because it's clearly a new way of working, especially when people are moving across borders. They are constantly being seconded here and there, one employer, a different controller, one paying the salary and another one managing the actual work. So it's clearly a
definitely, Raman, you can't disregard manpower agencies. I mean, it's a new trend, globally accepted, and there are tremendous benefits to them as well. So you really can't disregard that industry. But as you mentioned, regulation is key. Yes.
Yeah, I think so. Especially from an immigration point of view, I'm seeing, when an immigration officer knows that it's a particular manpower agency who's responsible for a team of workers, they are far more comfortable than if it's an individual employer who's bringing in a team. So in those ways, we have to understand there are advantages that we are yet to kind of explore properly, but exist. So shall we leave the manpower agencies for a minute and move to some of the other issues we wanted to cover in the seminar? I mean, I want to stop there and talk about it forever, but it's not very useful. The only thing I wanted to ask was that in terms of the arrangements, we see another series of arrangements is based on fixed term contracts or contractual arrangements, so that people are trying to move away from this employment arrangement into a contractual arrangement. And how do these things fit? Is it the same kind of issues that are coming up, or is it different? Dwaraka, you've been dealing with these questions for a few months now. Do you want to talk a little bit about it and tell us a little?
Yeah, sure. So yes, we've been getting a lot of queries in relation to managing the employment arrangement, especially from startups and initial investors, as to how can they kind of mitigate the risks that are involved in terms or that come across to them when in terms of the TEWA, right? So as Ramani had previously explained, when it comes to the TEWA, termination in Sri Lanka is quite strict. You will require either the consent of the employee or the Commissioner of Labor. But when it comes to a fixed term employment contract, it's stipulated for a particular period. So therefore, termination in that context is governed by the terms of the contract, right? So in that context, when it comes to startups who want to kind of test the labor market in Sri Lanka, who don't really understand or who are quite averse to the long-term feasibility options, they tend to go towards a fixed term employment arrangement. But one of the recent trend that we've been seeing, and which is a risk, is basically the continuous renewal of this fixed term employment contract. When this fixed term employment contract is continuously renewed on the same terms, there is a risk of this arrangement being converted to a permanent contract. So that means basically this triggers a termination clause, and therefore TEWA will be applicable. So in order to mitigate this risk, any such renewal should be on fresh terms and should be carefully managed. And we always advise our clients when we give them the draft of the initial fixed term contract, always come back for legal advice before you have a proposal to renew it, etc., because these sort of arrangements must be carefully managed.
Okay, understood. Now I see a hand raised. Mr. Waris, you have a question? Muhammad Waris, maybe it's an accident that the hand is up. Feel free to interject later if you have the question. So I see a question from an anonymous attendee that asking whether a Sri Lankan company who earns in US dollars can pay their employees in US dollars. And that question kind of leads into some of the questions that we were going to have about foreign exchange and earnings. So maybe we can start discussing the whole issue of labor migration. With this financial crisis, we are seeing a lot of concern in Sri Lanka about possible brain drain, people just voting with their feet, people lining up in queues outside embassies and applying for jobs all over the world, sometimes highly overqualified for the type of jobs they're applying for. So we've seen also Sri Lankan employers and also multinationals in Sri Lanka trying very hard to maintain their workforce with lots of incentives they're trying to offer. And among those is a series of issues that are tied to our foreign exchange. Hechika has, because of her expertise in foreign exchange issues, she's been dealing a lot with this type of question. They range from, can I pay my employee in dollars, as you asked, and other questions that come like, what am I to do now? I'm earning in dollars. The rupee has dropped so much. Can I pay my employees the current rupee value of the dollar, which we call pegging a salary to the dollar, and various other questions about also when I earn in dollars, what's going to happen to the dollars? Can I retain it in dollars or must I convert it into rupees in Sri Lanka? So Heshi, can I start by asking you to describe some of these ways that people have been trying to manage it, and then perhaps help us see some solutions to the issues that can arise?
Yeah, it's actually scary that Sri Lanka is heading towards or maybe heading towards a brain drain with the increase in labor migration. But at the same time, before I get into the ways in which the employers have tried to combat this, I have to say that another option that employees have been offered is remote working. Lots of foreign employers have opted to offer this option to Sri Lankan employees, and Sri Lankan employees have, in most cases, willingly accepted it as well. But what employees in this case are mindful of and need to be mindful of is the fact that in such cases, the Sri Lankan labor laws, which are very pro-employee, do not apply to such arrangements. And in most cases, or in almost all the cases, it has to be a consultancy contract that has to be agreed to. So, and of course, you can get paid in foreign currency in such cases. But the issue was also a few months ago, I think late last year, the government imposed a mandatory conversion of foreign currency, a principle that everyone who earns in foreign currency needs to convert it. And it was at a government-controlled rate. So, employers and employees, all businesses had to stick to this, but it was a mess. It was viewed very unfavorably. And but now the position is the central bank has gone back on it, and they have removed this mandatory conversion requirement. So it's no more in place. But what we did see during this time is, and also to, I think, address the whole labor migration issue in a sense as well, is that lots of employers, especially in the IT sector, did look to peg the salaries to the salaries of Sri Lankan employees. So pegging is actually, it's a benchmark. So the salary, which is normally paid in LKR in Sri Lanka, is pegged to a foreign currency. So because as most of you are aware, the Sri Lankan inflation levels are rising on almost a daily basis. And at the same time, the foreign currency was appreciating, the Sri Lankan rupee depreciating and the foreign currency appreciating. So most foreign exchange earning companies decided to opt for such schemes where they can enable the employees to benefit from the value of the foreign currency. So how it works is, I mean, the salary which they are normally paid is pegged to either the USD or any other foreign currency. And that would be what is eventually paid to the employees. So the salary includes fixed allowances, the provident fund payments, any other fixed compensation payments. But in most cases, we've had to advise our clients because in the long run, there are certain implications if the arrangement is not termed carefully. So we've had to, word the policies very carefully, because in some cases, companies are not able to continue this in the very long run. So we've had to advise on arrangements to kind of overcome these difficulties, which is something that we've done a lot in the recent past, as Ramani mentioned. So yes, that's what I can say, Ramani.
Sorry, Hechi. So if I take an employer who's earning in dollars and is paying their employee in rupees, but they want to peg their salaries to the dollar, and at the same time not be found to be liable to be paying that on a regular basis, what would I do?
You would have, I mean, in terms of, what do you mean, Ramani? Can you elaborate a little bit more?
No, how will I do it? Because I still want to pay my employees a little bit more to match with inflation.
Okay.
At the same time, I don't want to get into a situation where, everybody knows what their fixed salary is. This, how do I make sure that this is an allowance that is given at my discretion to tide over a weird inflationary period? But it won't be that in 2 years' time, when the economy is okay again, I'll still be liable to peg the salaries to the dollar.
Yes. So as I've said, this is a common issue that has come up with a lot of our clients, and we've been advising extensively on it. The wording, because, in all these cases, when you make a voluntary decision as a company to peg the salaries, it has to be a policy, temporary or otherwise, that you have to kind of implement and adopt. So what we've in most cases advised the clients to do is to state very clearly that this is a temporary special allowance, and that to always tie it up to a particular time period, because we can link it to the inflation, we can link it to the economic crisis, but there's always a battle of when does it end, where do you draw the boundaries. So in most cases, what we've said is specify a particular date and say that, give them the idea and make sure that the employees are aware that they are not as of right entitled to it beyond that. So that's a way to control it and make sure that employers are safeguarded as well.
Okay, that's quite clear. So it can't be a fixed amount and it shouldn't be forever. We should tell people in advance how much they can expect over a particular period of time. All right, I get that. So one of the things that I keep thinking is that, everybody sees Sri Lanka as a basket case and a place to be avoided, but I can see it the other way around too. It's a beautiful country. It has, because of the financial crash, of course, it's quite cheap to work and live in Sri Lanka. If you were to think of it in terms of dollars or pounds or euro, it's a very different thing from thinking of it from our perspective, which is from a Sri Lankan rupee perspective. And so I was very interested in seeing that the government of Sri Lanka was talking about this whole concept of a nomad visa, where they say you can come and live in Sri Lanka and work anywhere you want, and they'll give you a visa. Because usually to get a visa to live in Sri Lanka, you have to either be married to a Sri Lankan or have a Sri Lankan child, or you have to be working for an entity that supports your visa. But here they are offering you this new kind of visa. It's a new thing in the world, where you come and work here, you open a bank account here, and you get paid here, of course, and you spend your money here. Now, when it comes to these kind of things, and tying up with what you said before about this whole business of the conversion that was compulsory at one time, then these fixed conversion rates that were kind of not in line or commensurate with the real value of the rupee, those kind of things. There have been several proposals from trade unions, workers groups, migrant rights groups proposing that expatriate Sri Lankans or Sri Lankan migrant labor, when they bring their money back to Sri Lanka, then they are offered preferential exchange rate. Now, I know you're an expert on foreign exchange. Is that permitted under law to offer different rates of exchange for different groups? Is there a prohibition?
Right now, that's not very clear in the law, Ramani. It's something we may have to kind of refer to the DFE and get a clarification on. But from what I know, there isn't anything specifically in the law right now on that.
But there's nothing to prevent it either. Is there anything, Ayendra, like will this equality clause or something affect it?
It's difficult to say because the law is not, as Ishika mentioned clearly, the law is not clear in that regard. Of course, an argument could be made in terms of Article 12 of the Constitution as to whether that would be a violation of Article 12 in terms of equality. But it has to be tested, though. It's a difficult argument to arrive at a firm conclusion on.
Yeah, because the government will be arguing from the point of view of the interest of the economy and saying, you know, they are trying to.
Yeah, because even fundamental rights have exceptions.
Yeah.
Where as per the Constitution, you can restrict fundamental rights in certain circumstances.
For
so
the
government
national
can
economy.
Exactly.
Yeah.
So an argument can be made in that regard in defense of this decision. So.
Yeah, I'm hoping we can do something like that, because that will attract a larger group of people to come and live and work in Sri Lanka, because people love the climate, they love the people. There are good schools that teach in English, so your children's education is sorted, highly accessible. The airport is well functioning and very close to many of the world's commercial hubs. So I'm hoping we can do something like that. Meanwhile, one of the things we do see, though, because of all this labor migration, but also investor migration, is this whole issue of data and what do we do with data? Because we have personal data on employees that usually we have, like in any office, we have a little, you know, a book and everybody's names are written and their numbers are written and all the details are there. We have a card per person for their provident fund and all those, but it's all in paper and it's maintained in our office. So the possibility of a data leak is very minimal. But nowadays, life isn't like that. In fact, often payroll management is not done in-house in companies. They go outside, they send it out to somebody else to manage the entire payroll. And that includes people or people's personal details, their salaries, their bank details, all those kind of things. And with multinationals, they tend to send it all to a server somewhere in the world. It's not necessarily bound by national borders. And then, as I was saying, if we are trying to persuade people to take advantage of this nomad visa, it will be even more so. We will see personal data being transferred for employment purposes back and forth all the time. And so in that context, this new Personal Data Protection Act and its requirements are important, because as an employer, I must know in advance, what am I supposed to do with the data I have? How much flexibility do I have? What type of issues would I run into? You know, cybersecurity is such a big issue now that no employer on earth can protect total protection of data. So what are the things they have to do? And so Dwarka, you know, you've been working on this issue of data protection and cybersecurity for several years now. We've been watching this law come into effect. And in a way, having the law in effect makes us a much stronger country to invest in than, say, for instance, India, where the law was recently, the proposed law was recently suddenly scrapped, or in other countries, some of the other countries like Pakistan, where the implementation has become so complex, we don't know where it's going. So Sri Lanka is really at a different point. We have a law, but we don't have some of the regulations, so we can put together some of the best practices from around the world. But I'd like to hear from you. What have you seen in the last few months? Where do you think it's heading?
Yeah, so yes, so in March this year, Sri Lanka enacted the Personal Data Protection Act. And like Ramani said, notably we're the first country in South Asia to do so. So, and this, mind you, it was in the middle of an economic crisis. There was a lot going on, but when it came to the PDPA, we could see that the IT sector especially, they were pushing to get this act passed. And in the past 2 years, there have been 2 or 3 versions of the drafts, and there have been several discussions between the stakeholders. And actually, it was passed in March. But despite it being passed, it's not in operation yet. There is a maximum of 3 years grace period for companies that fall within the ambit of the act to kind of put in place measures and procedures to become PDPA compliant. Now, this PDPA is largely based on the GDPR, right? And in terms of Sri Lanka, this is not something new, because when the GDPR was enacted in 2018, we could see that because several of our IT companies, they have been already GDPR compliant since then, because they were servicing European clients. So they had to become GDPR compliant. So in terms of that, it's not entirely new for certain sectors in Sri Lanka, but there are several now who it's going to be of huge importance to are startups, the hospital, the medical profession, schools, etc. They will have to kind of ensure that they put in adequate measures to ensure that they become PDPA compliant, right? But in terms of where we are in Sri Lanka, the act has been passed. And as Ramani said, regulations and guidelines have not yet been issued. The act provides for the establishment of a data protection authority. This is also supposed to be established within this 3-year period. But in order to better understand the direction that Sri Lanka will be going on, we'll have to wait to see how these regulations and guidelines provide for that. We've actually we've been proactive in Sri Lanka has been proactive in terms of this whole data protection. Even when drafting this, it was not, it's largely based on GDPR, but assistance was sought from Singapore, etc., to kind of ensure that Sri Lanka we're aiming to become an IT hub. I know there's a whole economic crisis that's going on, but that has been a part of the agenda. So in terms of that, we have sought to kind of ensure that this is globally compatible. And when we look at the PDPA in terms of the labor laws per se, how it can become applicable in terms of the new work arrangements, we could see that, like Ramani rightly said, with all this remote working, there's going to be a lot of cross-border transfer of data. And even intra-company, when MNCs come and establish in Sri Lanka, intra-company transfers, etc., right? So this would mean that an employee's personal data is transferred between countries. And when you look at the PDPA, the Act provides for instances where cross-border transfer of personal data is permitted. But the key here is to obtain the express consent of the employee after informing them of the risks of such transfer and the manner in which their personal data will be processed. So that would mean their employment contracts, all of that will have to be relooked at and amended to ensure sufficient clauses are included, right? In addition to that, the companies also should ensure that, you know, their the measures that they have put in place, whether it by holding these records physically or online, are sufficient to protect this data, because there are certain rights that are given to data subjects. But when it comes to employment laws, there are certain statutory obligations as well on these companies or on employers per se. So, and the Act provides for compliance with that. So that there is this sort of manner in which they will have to manage it while being compliant with the labor laws of Sri Lanka. And also when it comes to cross-border transfer of data, just to add in, the Act does recognize transfer of data to any countries recognized under an adequacy decision. But as Sri Lanka is in the nascent stage in terms of where this Act is, there aren't any regulations that are published recognizing certain countries. So recognizing countries that could be recognized under an adequacy decision. But because this Act is largely based on GDPR, it is most likely that European countries will be covered under this, but we will have to wait and see. And we will have to wait and see the establishment of the DPA, all of that, to see how, in which direction they will be going forward.
To link it back to all the conversation we had about manpower agencies, who is the employer in these situations, then we've also seen Ishi and I, and even you, we've seen all these new forms of work opportunities for Sri Lankans, right? And we are also trying to promote that. For instance, there seems to be a world obsession with tuition, extra tuition for children. And the Sri Lankan teachers have hit the popularity rating on that. So there's a lot of teachers now who are getting involved in online tutorial provisions for school children, even for university students. And so in all those situations, like if you take the manpower agency versus the employer, in that example that Ayendra gave, well, there's a manpower agency, we call that company B, and we'll call the workplace company A. Now company A processes all the payments and pays it through company B to employee. Similarly, the teacher manages a classroom of students that include all the information about the children, but the employer of the teacher, who is the owner of that teaching service, is also managing the data. So in all these things, all these words that you all use about data controller, data processor, how does it add up? Take just the manpower agency. Who is the data controller and who is the data processor in that example?
So yeah, if you look at it in that context, it will always be the employer per se.
But who is the employer for this purpose?
So in this, I mean, so that's, I mean, that is up to the child, that ties up to the confusion, right? In terms of, ideally, under the PDPA, it should be the person who determines for which purpose the data is used, right? So then if you look at it in terms of the labor law implications of that, and I think then there is that whole confusion of who is the employer in that context. Am I right? Is it the
Ramani, I think Ramani's question Dwara covers, I think saying in my example, if say the company who is hiring the employee from the manpower agency and who is making the payment to the employee through the manpower agency, in that example, who is the, how does the data aspect come into play?
The employer, that would be the data
The company.
Correct, the company,
Okay.
Because they are the ones who will determine, they would control basically the data, right? So they would ideally be the data controller. But then again, in terms of all these arrangements globally, we've seen in terms of cases, etc., there are different ways in which different countries approach this, right? So that's what I said, much will depend on the direction that the Data Protection Authority will also take and like how they would interpret it, right? So they would take, I mean, they're going to take guidance from other jurisdictions, but in general, if you look at it in that context, it would, the data controller would be the company. and the manpower agency would ideally be the data processor.
Okay, so the Personal Data Protection Act is only one of a series of new laws that will have an impact on the labor landscape in Sri Lanka. We've been studying all the different new laws and also some of the proposed new laws. And I thought maybe starting with you, Dwarka, I'd like to hear a little roundup for our participants on what the latest updates are, but also what can we expect in the future?
In terms of the new laws, right?
Mm-hmm.
Yeah, so for example, I mean, there has been a recent amendment to the regulations issued under the TEWA. So previously, like, okay, just to give you a bit of a background, the regulations under the TEWA provides for the computation formula that the Labor Commissioner follows when employees are terminated with the consent of the Labor Commissioner. But this formula is also a guideline when employees are terminated with the consent of the employee, because when these employers offer these VRS schemes, they use this as a guideline and then seek to offer an amount that is slightly higher, right? So previously, this computation formula, if you look at it, I mean, in general, it takes into consideration the number of years worked and the salary when computing this compensation. And the maximum was capped at 1.25 million. However, like if you look at like in larger companies, people holding senior management positions, this was not very favorable to them because they were earning a higher salary. So there was a lot of call for reform on this. And in the latter part of last year, the cap has increased, and now the maximum cap has been increased from 1.25 million to 2.5 million. So that was one of the recent amendments that we saw. Then last November, there was a minimum age of retirement act that was passed, which sets out a minimum age of retirement for private sector employees. Earlier, this was purely contractual and it was governed in the terms of the employment contract, but now it's statutorily provided for and it's 60 years. There is also another proposal to amend the Shop and Office Act to facilitate night shift arrangements for women. So when you look at Sri Lanka, right, in the recent past, it has been navigating towards a service economy. So there has been an increase in investment in the BPO and IT sector. And this also means that employees have been required to work in accordance with foreign timing. But when you look at our present labor laws in its current form, it prohibits women from working after 8 p.m. unless Labor Commissioner approval is provided. But despite this, the practice is we've seen employers have required women to work after 8 p.m. anyways, with or without the approval. So this cabinet approval, this proposal to amend this law kind of makes it clear that the conditions of night shift working for women will be better regulated. So we are waiting for the act to be amended. So these are the main few amendments that we've seen in terms of the labor laws.
You were talking about this whole TEWA and the voluntary, the VRS packages and the formula. These things are based on an inquiry often at the Labor Commissioners. And one of the things that I've heard over and over again in the last few months in Sri Lanka is that these discussions with the Labor Commissioner is taking too long. Employers are getting anxious. They feel that there is no way out of a situation. They want to offer people a decent package, but every month that it gets delayed, the amount of money available gets to be less and less. Ayendra, can you tell us a little bit? I mean, are there time limits for these inquiries? How would it work? I mean, how can we make it better, more efficient, so that everybody gets the best package available?
Yeah, so basically, Ramani, in terms of the Termination of Employment of Workmen Act, or TEWA for short, there are two types of inquiries envisaged there, right? So you get one inquiry where, say, an employee is terminated and he files a complaint for the commissioner on the basis that he was let go unlawfully, right, in violation of the act. In that situation, the act provides, section 6B, I believe, provides for a time limit. It says 6 months time frame for an inquiry. Strangely, however, there is no time limit given or time frame given for an inquiry that is held in consequence to an an application made by an employer to obtain the consent of the commissioner to terminate an employee. Okay, so there is no fixed time frame given there. So it could take 6 months, it could take more. So in which case an employer who seeks to get the consent of the commissioner to terminate an employee, that application might take at least, I don't know, might take even a year to process, right? And I think even more than that, we also have to bear in mind that that consent may not be given by the commissioner at the end of the inquiry. Okay, so say if it's an employee who is redundant now, when you want that person out, and you make an application to the commissioner, and you go through this entire long process, and there is no guarantee you will get the commissioner's consent in the first place. So that's another problem. So as regards a way out, yes, I mean, a time frame will help, maybe 3 months time for the commissioner to give a determination with regard to whether or not consent is given. But ideally, I think there should be a system where the withholding of consent should be minimized. I mean, if for example, an employee has become redundant, the better course of action would be to ensure that compensation is paid and the employer is given the opportunity of letting that person go. Again, that's my personal point of view. I think it should be on compensation rather than consent. Because if the employee is adequately remunerated in that situation, I think the employer should be given the discretion, except maybe in limited circumstances, to terminate the person. But this refusal of consent can be a problem. Yes.
Yes, I agree. But I'm also talking of these mass scale restructuring programs where you're talking about taking 300 employees and making them redundant overnight. So when they're doing it, I suppose a 3-month program is fine. There's also some issues around taxes, whether these employers have been, filing their documentation right, whether they have been making the superannuation contributions properly. So I think now with more and more of the systems getting automated and being more readily available in terms of information, I'm hoping there'll be a lesser time lag between these questions and the actual new things. In terms of the women's night work, I work a lot with women's trade unions, and this is a huge issue. Women are forced to work very often under very unfair conditions that they find very difficult to even talk about. And so I'm wondering, in these new regulations that are being proposed, are they going to also talk about conditions for women to work at night? Or is it just going to be like, okay, men are allowed to work at night, therefore so shall women? Is that how it's going to be?
We will have to wait and see, Ramani. I mean, as of now, we are not too clear on that. We'll just have to wait and see how. I mean, if you look at the current act, as when it talks about the hours of work, it just talks about the hours of work per se. That's it, right? So we'll just have to wait and see whether there'll be anything in addition to that or any further amendments will be introduced.
Yeah, because all our excitement is because we can see the shift work for IT workers and people like that who are often working from home. But the larger group of women in Sri Lanka work in the manufacturing industry, and that's where they face also a lot of pressure when they're working at night. So it would be good to see some of these other additional duties that the Labor Department would have. Speaking of the Labor Department and all these issues that we are seeing coming up, is anyone going to talk about whether the EPF can be invested outside of the regulations by the central bank and things, or we are going to leave that for another meeting altogether on investments? Heshi, you have any comments on that?
It's a long discussion, Ramani. Let's leave that for another time.
Okay. There was this question that came up in the Q&A about the dollar earnings. Can I retain my earnings in dollars in Sri Lanka? Or is it essential to convert it into rupees?
No, right now it's not essential because, as I said, the mandatory conversion has been lifted. So it's not essential to convert it. No. Yes. So you can be paid, I mean, as a consultant, for example, you can be paid in USD or any other foreign currency, and you can maintain it like that as well. If it's an employment in Sri Lanka, however, there is this whole, I saw a question on the Q&A as well. Of course, it's not a specific provision in the law which says that you cannot be paid in USD, for example, but there is a provision which says that you need to be paid in legal tender, and legal tender is Sri Lankan rupees. So, but the thing is, and also in addition to that, when it comes to EPF, ETF payments, all employees need to be paid EPF, ETF, and that's paid in rupees. So you run into a bit of a mess there as well if you pay in USD, because every month it's going to be a different amount. So I think employers in general do pay in LKR in Sri Lanka.
But hopefully they can change that so that, the amount is fixed in USD and the different amounts can be paid in rupees for the Provident Fund, no? Rather than the other way around of taking away these people's opportunity to earn in dollars for the moment.
Yes, I know it would be more beneficial that way. But I mean, there is a bit of a lack of clarity there as well, because as I said, the law says that you need to be paid in legal tender, and it's defined to be LKR. But as you said, it would be more beneficial if people are paid in foreign currency, and EPF, ETF payments could be made in a way that it doesn't become so messy at the end of the day.
So one of the things we are seeing nowadays, because we are seeing Sri Lanka is about to commence very serious negotiations via the IMF with its creditors, and we will be expected to go through a very strong series of restructuring and especially restructuring of the ownership of many of the state-owned enterprises. With that, we can also expect a lot of layoffs. And one of the requests forever from investors into Sri Lanka and also from the IMF has been that the law, which we call TEVA, on employment, termination of employment of workmen, be abolished. Do any of you have any thoughts on that? Do you think it plays a useful role, or is it a hindrance, or can we move to a model like what Andre is talking about, where we have a hybrid? What do you think, Andre?
I don't know if abolishing TEVA will. I think you have to bear in mind that you look at the interests of both the employer and the employee, right? So I think keeping that in mind, retaining TEVA would be a good thing, subject to amendments, I feel. Because you have to have some kind of regulation. A simple hire and fire system will not do in safeguarding the rights of the employees. But at the same time, I think you have to have a law in place which will look at the realities of business when it comes to restructuring and so on, whilst at the same time safeguarding the rights of the employees. Because the TEVA as it is right now, I feel personally that it doesn't take cognizance of certain business realities, modern day realities. And I think the simple consent method might not be sufficient in keeping with how the world is progressing. So I think an amendment to the TEVA in a way that we take cognizance of present business realities, whilst at the same time we look after the interests of employees, would suffice. I don't think abolishing TEVA completely will, I think, benefit anybody.
Especially given that our country doesn't have a proper, like a social welfare network or unemployment benefits or anything like that. So there's nothing to cushion an employee who is suddenly terminated. Yeah. And, there's a lot of pressure from investors to reduce the level of taxation on them. So we can't also ask them to voluntarily contribute to a social welfare network like they've done in some other countries. So I don't know how that would progress in the future, actually. But it's an important thing to keep in mind. one of the things I keep seeing is this whole conversation about the Colombo port city as a kind of a model for how we can move forward. One of the things I saw there is that the Colombo port city people can be paid in US dollars, will not be taxed if you work in the Colombo port city, but there will be no TEVA applicable in the Colombo port city. So maybe if you have all those options, then maybe you can do away with TEVA. What do you think?
Well, again, the Colombo port city again is a controversial subject, Ramani. I mean, the act itself, there are so many discussions and debates as to whether those provisions are suitable or. So again, I don't personally agree with suspending TEVA completely, even in the context of the port city. But again, that's a very big topic. But whether it can be used as a model that we can follow across the island, I'm not sure. Port city, of course, they're following a financial city model, like in the case of Dubai and so on, where different laws will apply. So I suppose an exception can be made there, since we are looking to attract investors for that particular region. But whether we can apply those same principles island-wide is a different matter altogether. So I don't know whether that can be called a good example in that regard.
And the other argument I saw was, we are trying to stem a particular level of very high level of brain drain. So if we can offer some of these benefits to the high level management or say mid-level management, but still offer the protection of laws like TEVA for our unskilled labor, then maybe it would work. Because as someone was saying, are you going to really pay the cleaning lady also in dollars in the port city and then say, tomorrow don't come to work from tomorrow? Is that possible in our country? And I think we have to admit that we treat our workers quite decently. And, we have to stop soon. But before stopping, I'd like to think that we are currently in a financial crisis. But if you think of other countries that have been in similar or worse financial crises, I suppose Bangladesh and Vietnam in our own region come to mind. They were very seriously affected after the war in Bangladesh, after the shift in regime in Vietnam. They were ailing economies, and now 30 years later, we are seeing totally different countries, forward-looking, amazingly innovative in terms of Vietnam, amazingly good neighbors in terms of Bangladesh. They are really leading our region in terms of decent investment, decent democracy, and at the same time, decent workforce. Also, right now, I am based in Amsterdam, and I am seeing the impact of just permitting abolition of laws like TEVA. So in just the airport, which was probably won all these awards for the most efficient airport in the world. During the COVID, they laid off all their security personnel. And now nobody wants to work for the Schiphol Airport Authority anymore. And they're having queues which are 6 to 8 hours long outside the airport to complete security, and virtually everybody is boycotting the airport now. So very soon the airport is going to crash. So you see the consequences of not having a decent framework, even in order to attract investment, is not very useful. It may be better to think of suspending certain types of taxes, providing for better ways of bringing raw material into the country, in terms of customs duty waivers and things, and also really placing Sri Lanka for what it is. It's next door to this huge market. We have a duty-free arrangement with India. So, any industry that invests in Sri Lanka with the kind of educated, disciplined workforce that Sri Lanka has a huge market that they can sell to. It's not just our 20 million people. So I think there's all those potential. But in the meantime, I think we have to agree that all of us have to keep a very close eye on the next few months and what's going on in labor and employment practices and regulation and deregulation, and be ready to work very fast on that. On that note, I think it was great to be here. I'm not sure whether we've answered all the questions. You are, of course, very welcome to write to us directly or via Legal 500 if you have any more questions. It was great to be on this panel with the three of you. And Margarita, thank you so much for your input and introduction.
No,
I'll hand
thank
over to
you,
you.
speakers. Thank you. It was thank you for your insights. Yeah, thank you very much. We did have a couple of more questions. Maybe we can answer one, considering we have 5 minutes left. So I think, Ramani, that's for you. The audience wanted an example of data protection queries you have to deal with at the firm. So if you could bring some examples or one example to the audience attention.
Yeah, data protection has become a key concern now for Sri Lankans and also for people who work and manage work in Sri Lanka. So the key issue has become, in terms of labor law, has become the whole matter of payroll management. And when you're taking the payroll out of Sri Lanka into servers that are placed somewhere else, what are your responsibilities? How will you manage it? Is it enough really to just in your employment contract to remind the employee that your data will be migrated to other countries, to Dwarka? Would that be enough, or do we need to do anything else?
So yeah, generally, like in terms of, like now, if you look at EU, there are certain standard contractual clauses that have been issued where, like, you know, certain for contracts where there is a cross-border transfer of data, certain clauses have to be included, right? But in Sri Lanka, we are yet to see that, but we might possibly follow such a model whereby such clauses might be recognized in Sri Lanka. So that possibility is there. In the absence of that, what we recommend to our clients is to like ensure that, you know, you draft the clauses like in a very detailed manner in order to ensure that the employees are aware to which countries their personal data is being sent, the purpose for same, and for how long, etc. So all the details must be provided.
Is that good, Margarita?
Yes, that's good. And do you think you would be able to reply to this question in 2 minutes, a minute? How is the child labor situation in Sri Lanka, and how is the new regulation going to address it?
Well, child labor is banned in Sri Lanka. It's actually only seen in the informal sector. In the formal sector, there is a complete blanket ban, and that is adhered to by all employers. In terms of the informal sector, that's a very difficult issue because child labor is a hidden issue in Sri Lanka. It's domestic labor mainly, and assistance in certain types of industries like auto mechanics and also urban food stores. So those three areas are all highly unregulated in general. And when children are hidden as employees, their vulnerability is worse. We have an amazing probation and childcare service. We have a special unit in every city. In per labor office, we have a child labor officer. We have a lot of intrusive almost review of family life in Sri Lanka, because we also have a compulsory education law that requires all children to go to school until they are 15, which is compatible with the age of employment. So there's a way in which there's a second tier of review, because you can know when a child is not coming to school. But I'm afraid it still exists, but it's a completely different situation from 10 years ago even.
Thank you. Thank you very much. For the audience, if you, as mentioned, if you wish to watch the webinar back, you're going to find it on our website. I wish everyone a good day and thank you again for your insights.